Yo, I swear it's only up from here. 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 I hold my chest when I drop these. Once upon a smoke unconscious. Go ponder trauma responses. No return to sender till you bones to pick. Devil on his own agenda. Fully loaded when it renders. This that lonely bender on the strip. Feeling solo at the party and the low he's dipped. D totaled the whip, best way it could go. Last know is the Van Wick, he evaded the nose. Don't call a coyote ugly or a pony quick. Do remember, it's all heard, elephants don't forget. I want the dude to even make those 40 years. Shorty blowing smoke rings across the lawn, you know the gist. Yo, I swear it's only up from here. Yo, I swear it's only up from here. Yo, I swear it's only up from here. Yo, I swear it's only up from here.
What up? What up? What up? Peace, Oakland. Breaking news. I had to go live. Had to get it out. It is over, Oakland. It is over. The city of Oakland just lost the final appeal in the California Supreme Court on the Cole lawsuit. After 9 years, tens of millions of taxpayer dollars set on fire in a bankruptcy case in Kentucky that could pull Oakland down with it, the city lost. So Cole is coming whether you like it or not. Again, 9 years of moral posturing, empty promises, and no Cole in Oakland protests, all ending in the exact opposite result. So that's Oakland governance in a nutshell. They lose the game, and then they hand us the bill for season tickets, taxpayers. So here is a basic legal history of this 9-year soap opera for those of you who are not up to date. So back in 2016, Oakland made a deal with OBOT, a 66-year ground lease for a bulk terminal at the old Army base. The city of Oakland and then Mayor Libby Schaaf knew which commodities could move through, and they signed on the dotted line. They knew coal was coming. And then came the politics. Under pressure from activists, no coal in Oakland in the Sierra Club, mainly having every single person and their mama signing loyalty pledges that coal would never come to Oakland, the city passed a coal ban in 2019. OBOT immediately challenged it, and in 2020, in the Ninth Circuit, they ruled that Oakland violated the agreement. So translation, you can't make a deal, take the money, and then run away screaming, just kidding. So in state court, Oakland kept dragging its feet, throwing up roadblocks and playing more games, basically serving as both the landholder, the landlord, and the regulator. In January 2024, Judge Noel Wides told us and ruled what we already knew. The city of Oakland was in the wrong. The original lease stands. But of course, they don't care about our money, so Oakland appealed again. And in 2025, the appellate court doubled down. Now the Supreme Court just let that ruling stand. Case closed. Oakland also sent lawyers all the way to Kentucky to try to block the bankruptcy of an OBOT sublease, Insite Terminal Solutions, or ITS. And now ITS is suing the city of Oakland for $1 billion. And they will very likely win. And as I've been saying on Gotham, Oakland, this will bankrupt the city. It's hard being right about this stuff. And Oakland's own consultant, Northgate Environmental, found that that uncovered coal cars were not significantly impacting West Oakland's air quality. That's their study, not OBOT. And the city of Oakland uses Northgate all the time. But when the science didn't match the politics, they buried the study. That's like failing your own open book test. Meanwhile, City Attorney Ryan Richardson misled City Council. The city let itself get hijacked by special interests. And as taxpayers, we got stuck with the bill again. And this bill is not just going to be the $30 or so million in their legal fees and our legal fees. It's going to be a lot bigger, like I've said. Bankruptcy. So the Sierra Club and No Coal in Oakland, they can throw rallies, they can chant slogans, they can pass around loyalty pledges like friendship bracelets at summer camp, but coal is shipping anyway. It's like protesting gravity. You can shout down with down all you want, but that apple is still going to smack you in the head. In Gotham, Oakland, we've been the only media outlet calling this straight. We want city council, we want the city, we want the activists. But here we are, exactly where we said we would be. And where was the Bay Area press when the city lost the last appeal? Nowhere, not a peep. The same folks who sent 3 reporters to cover a new vegan donut shop couldn't be bothered with a $160 million lawsuit Oakland just torched your tax dollars on. Journalism in Oakland is like PG&E power lines, unreliable and usually on fire. So here's the moral of the story. If you're going to pick a 9-year legal fight, don't do it against both the Constitution and basic contract law. That's like betting your rent money against Tom Brady in the Super Bowl. Spoiler alert, you lose. Now the question is, can Oakland stop trying to play the savior of the planet and just try running the city decently? So strap in, we're only getting started. Peace, I'm your host, Seneca Scott, and if you are watching Gotham, Oakland for the first time, we're the only local news show that is not dog walked by the same people we're supposed to be holding accountable. We're the only local media that is basically not serving as public relations for City Hall. If we ever got an interview with them, we would actually ask real questions that are relevant to taxpayers. But anyway, let's get into it. I got some things to share. First out the gate, let's talk about this ruling real quick. Sorry I can't make it bigger, but if you make your screen bigger here, you see this shows the whole history of this case. And on the 17th, that is today, as of a few hours ago when this posted, the petition for review was denied. That means the Supreme Court has said no. Of course they did. The Supreme Court never hears cases where you lost both the lower and the higher courts, especially over contract dispute, especially over where there were, I think, 16 counts of force majeure that the city of Oakland lost on. But does that stop the No Colon Oakland from throwing a rally? Nope. Yesterday, they hosted a community meeting. Let's get a little insight into what No Colon Oakland is saying. No Colon Oakland coalition meeting, 4 p.m. Tuesday, September 16th. No Colon Oakland is a grassroots coalition campaigning to stop the threat of coal being transported by rail into Oakland for export overseas. Through the Oakland City Council, the city's mayor, and politicians at the state and local levels are on record opposing coal passing through Oakland. The proposal to build a massive coal terminal at the foot of the Bay Bridge remains tied up in both federal and California lawsuits. It's not tied up anymore and decidedly on the table. Oakland has long been a center for highly polluting transportation activities, resulting in disproportionately high health impact for the residents of West Oakland. Our community has made some progress towards systemic reduction of pollution caused by these activities, but Oakland can't and won't allow toxic coal dust to erode modest gains and further threaten our health. Coal is the dirtiest fossil fuel on Earth, imperiling the health of workers, endangering communities along rail lines that transport it, and contributing greatly to global warming and climate change. All sounds very urgent and real until you realize it's bullshit. They lied. Let me show you. Let me show you. Okay, here we go. Sorry, I'm live. I'm getting my stuff together here. I used to get to do this in the studio and edit it later. All right, check this out. Check this out. Check this out. I'll make it bigger so everybody can see it. Okay. May 23, 2025. Everybody in Oakland City Council has seen this letter. City Attorney Ryan Richardson has seen this letter. No Colon Oakland has seen this letter. And I'm going to read it so you will have seen this letter. And then you can ask yourself, why are these people lying? Like no one's ever, oh, I know why they're lying. Because without us, you wouldn't even see this letter. Without Gotham, Oakland, you would never see this letter. That's why they feel so comfortable lying. Let me show it to you. Let's read it together. Phil Tagami, President and CEO of California Capital and Investment Group, regarding the review of ambient air quality monitoring results at the Oakland Army Base, Oakland, California, Northgate Project number 10485.01. This letter is to Mr. Tagami. This is no longer privileged and confidential. I've been allowed to share it. Whistleblower I'm blowing the whistle. It's not confidential anymore. I'm blowing the whistle. But here's what they tried to bury. Mr. Tagami, on behalf of California Capital and Investment Group, the Northgate Environmental Management prepared this letter presenting the results of our analysis of potential ambient air quality impacts associated with rail cars carrying uncovered loads of coal through West Oakland. Ambient air quality monitoring was performed at the Oakland Army Base in the West Oakland Gateway area and the West Oakland community on behalf of the developer and the city of Oakland during construction activities at the Oakland Army Base. Based on our analysis of available air monitoring data and rail logs, it was determined that rail cars carrying uncovered, remember, we had a covered coal deal on the table the city turned down, carrying uncovered coal around the Oakland Army Base did not result in a measurable increase in the regional PM 2.5 levels. These findings indicate that uncovered coal cars did not significantly contribute to regional air quality impacts in the West Oakland community. That is the exact opposite of what the environmentalists have been pushing. Keep in mind that we've been shipping coal through Richmond nonstop for years, and we can compare Richmond's air quality to here. From a rigorous academic level, we have shown, or not we, the Northgate AQM has shown that there is no measurable air quality. Let me go into the fine print. Ambient fine particulate matter, PM 2.5, concentrations were monitored continuously at 3 air monitoring stations during the Oakland Army Base redevelopment project, later called the project, in Oakland, California. The monitoring was performed on behalf of the city of Oakland. Think about that. The monitoring was performed on behalf of the city of Oakland. So they knew about it because the monitoring, again, was performed on behalf of the city. During the infrastructure and horizontal construction phases of the project and on behalf of the Prologist CGIG Oakland Global, the developer, during the vertical construction phase of the project. Ambient PM 2.5 concentrations were logged at 1-hour intervals for the duration of the air quality monitoring program. These monitoring results were shared with the public via a dedicated web portal and were generally reported on the Bay Area Air Quality Management District on a quarterly basis. In 1995, the Federal Base Realignment and Closure recommended closure and realignment, disposal of the old Oakland Army Base. The U.S. Army, the lead agency for the base closure and transfer, conducted or participated in the required environmental process pursuant to the closure and conveyed the majority of the OAB land to the Oakland Army Base Reuse Authority. Upon the BRAC Commission's recommendation to close the OAB, the City of Oakland began to evaluate how to best implement the reuse of our OAB in surrounding areas. The city investigated the redevelopment options, designated a redevelopment survey area, and in 2000 adopted and approved the Oakland Army Base redevelopment plan and established an 1,800-acre redevelopment project area, including a 330-acre OAB. I'm not going to read all 13. Let me go through the 13 pages, but let me go through the coal train. A log of trains with uncovered coal car units that traveled through West Oakland was provided by Union Pacific Railroad and compared to the West Oakland Regional Air Quality Monitoring result. This data set includes 115 days with at least one uncovered coal car passing by the aforementioned regional air monitors. The log showed up to 104 uncovered coal cars recorded for a given train. A table summarized the number of coal cars, daily average PM 2.5 results, and maximum 2.5 results is attached as Table 1. As shown in Table 1, air monitoring results collected on days with coal cars were consistent with air monitoring results on days without coal cars. And here is the data. I'm not going to read all that. I'm going to put this link into the, I put the PDF into the story or into the link so you can read it yourself. But here is the conclusion. Based on our analysis of available air monitoring data and rail logs, Northgate has determined that rail cars carrying uncovered coal around the old Oakland Army base did not result in a measurable increase in regional PM 2.5 levels. These results indicate that uncovered coal cars did not significantly contribute to regional air quality impacts in the West Oakland community during the monitoring program. And then they have all of the studies and tables for you to go and look through. Never saw the light of day. Never saw the light of day, but the city of Oakland knows about this study. People who have sworn loyalty pledges to No Coal in Oakland and the Sierra Club know about this study. They know about it. I have covered this lawsuit exhaustively. I have even shown you the court themselves dressing down the city of Oakland, asking about force majeure and why they continue to push the issue. Matter of fact, I'm going to show you just that scene for the next 10 minutes or so, then I'll wrap it up. But breaking news, it is over. The city of Oakland has lost the coal lawsuit. If you're watching, give me some of your thoughts. If you're watching on YouTube, if you're watching on X, leave your comment down below. I'll get to them when I'm no longer broadcasting. But we need to talk about this. The Sierra Club and No Coal in Oakland have absolutely hijacked our city attorney's department. Now we face bankruptcy because of it. Now we face bankruptcy because of it. The city of Oakland sent lawyers to Kentucky telling them that Insite Terminal Solutions did not have a valid lease, and therefore they were insane to ask for any money at all in their bankruptcy. ITS was valued at $1.2 billion, give or take. $1 billion valuation. I think they got less than $100 million in bankruptcy, significantly less than $100 million in bankruptcy. They blame the city of Oakland because the judge believed their letter. At the time the city of Oakland submitted the letter, it was in a sort of a legal quagmire, and the judge could not ascertain if the lease was valid. Now that it is abundantly clear that not only was the lease valid, but the city of Oakland spent 9 years illegally acting in bad faith, we're going to lose the bankruptcy case in Kentucky. Now, it's not going to be for $1 billion, but it's going to be for probably a couple $100 million. Oh, fun fact, the number one thing ITS wants to know about the city of Oakland is financial disclosures about the Coliseum. The city of Oakland claims under oath in bankruptcy court that no such documents exist. Now, I don't want to go down that rabbit hole because we're talking about this today. Let me go to the episode on Gotham, Oakland. Why I am looking for it. The coal-fired lies. Okay, here we go. Let me pull it up.
Analyze those two issues without a clear understanding and analysis of what.
And I don't want to jump ahead to your bad faith. I don't know if you're going to argue the bad faith case of this or not, but, and I know you contend that there's no bad faith, and you make similar arguments, I guess, but how is it, or maybe I shouldn't ask how is it, but the judge found at least, and find, there's at least 12 mentions in her statement of decision of bad faith or breach of the covenant of good faith and fair dealing.
Yikes, that didn't sound too good. Peace, y'all. This is Seneca Scott, your host of Gotham, Oakland. Well, we don't need to hear the monologue. Let me just get right into the case.
Experienced real estate developer entered into a heavily negotiated 66-year lease. This is it. It's volume 6 of the appendix. This is the ground lease that is at the heart of this case. It's 500 pages of carefully negotiated terms, extensively negotiated terms that balance 3 things really: risk, responsibility, and reward. OBOT went into this with eyes wide open and assumed all the risk of regulatory uncertainty and market uncertainty when it agreed
By the way, we fired this lawyer. The city of Oakland got rid of her before we went to the last appeal. She's
by very
terrible.
specific deadlines to start construction of a bulk terminal on the city's land. Eyes wide open about the fact that the city was going to legislate with respect to coal. It knew that at the time that it entered into the contract and agreed to those deadlines.
Lies.
Article
Lies.
6, Section 6.2.1 is where you will find the steps that OBOT agreed to move this through the process. And
Ms.
while-
Leonard, you said that OBOT knew that at the time that it entered the contract that Oakland was considering something to do with regulating coal. What are you referring to, and where is that in the record?
So that is, I'm referring to, there was already a September 2015 hearing in which the city of Oakland started the legislative process with respect to coal. Everyone knew that there was brewing a pretty serious dispute over the city's ability to legislate with respect to coal. This deal was done because the parties agreed to set that to the side and move forward anyway.
The development agreement was earlier than 2015. So how does that play into this argument? That is, weren't they already basically committed, or could they have, how did that work?
Article 5 specifically says that nothing the city can do in its legislative or regulatory capacity would interfere with OBOT's deadlines. OBOT agreed to all of that. That's the balance of risk, responsibility, and reward.
Listening to you and your eloquence and your emotion, how is it that a judge listening to all this for weeks writes a 95-page statement of decision rejecting your position basically every step of the way? I mean, are you going to get to what Judge Wise found and decided, or are you just going to talk about reward and the size of the lease?
So, of course, Your Honor, of course. So what Judge Wise decided was that force majeure and the implied covenant should rewrite the terms of this contract. And
Okay. I don't need to bore y'all. It's over. You can watch that episode of Gotham if you want to get into it. And you can watch even more if you want to know about the Kentucky bankruptcy case. And I will be doing another episode on that next week because we have some updates there. So I'll leave some closing thoughts. As we have said now for, over a year since we started Gotham Oakland, there are a couple major themes that really illustrate just how corrupt the city of Oakland is. In the No Coal in Oakland, hijacking our city attorney's department, the Sierra Club, hijacking our city's attorney's department, multiple elected officials signing loyalty pledges to these environmentalist entities over their oath of office to taxpayers, and we pay them, has led Oakland to not only losing this lawsuit, but also probably going bankrupt from the other lawsuit. Now, I know I have said that 5 times, and I can't say it enough. I want everyone to remember who said this and who is the only news agency to report on it, so when it happens, people can't hide. You can pull from this tape over and over and over again. Here's the good news. Oakland is in dire financial strait, and we need this economic development. You're talking hundreds of jobs and hundreds of millions of dollars in revenue to the city of Oakland, not to mention $900,000 per year in rent money per year that we could have been getting for 9 years that we didn't get, but we'll be getting it now. And yes, very likely coal will be shipping through. Oh, I just lost a light, my signal to get up out of here, but coal's coming through. The studies showed that it did not have the environmental impact that the environmentalists said it did. They refused to even acknowledge the existence of this study. They refused to acknowledge the existence of this study, and we all know why. Hold them accountable. City Council, I'm watching you. Ryan Richardson, we ain't done with you, bro. This is good. This is not okay. Once we're bankrupt and it's your legal advice that got us here, it's time to recall you too. Peace, Oakland. I love you. Take care of yourself. Beautiful day. Go outside, ride a bike, walk around the lake, touch some grass, do stuff.
Yo, I swear it's only up from here. Yo, I swear it's only up from here. Yo, I swear it's only up from here. Yo, I swear it's only up from here.